Good afternoon, everyone. Welcome back to the Decommissioning Theatre. We've got another session of partner spotlights and industry perspectives. We're going to kick off with an industry perspective from Clifford titled Navigating an Oil Field Minefield, Managing the Legal Risks of Decommissioning. Please join me in welcoming Pat Saraceni and Kristian Maley to the stage.
Thank you, Sean. Kaya, it's a pleasure to be here on Wajak Noongar country, and I'm really pleased that you're all so interested in turning out to see a bunch of lawyers talk about decommissioning. I'm Kristian Maley. I'm a counsel with Clifford Chance's Disputes and Risk Management team here in Perth, and I'm here with my colleague.
My name is Pat Saraceni. I'm a director at Clifford Chance.
So the legal risks in decommissioning, it's a pretty broad topic. So today we've narrowed down on a few specific issues to talk about. I think I've just broken the slides. Here we go. We're going to focus on two aspects: procuring decommissioning work and also the operation of the trailing liabilities regime, just to keep things a bit tight. And then we'll finish off with some key takeaways to hopefully give you some practical pointers to leave us with today.
Okay, thanks, Kristian. I'm sure all of you feel the same, but it's an exciting time to be involved in decommissioning in this country with some $40.5 billion worth of decommissioning work. There's clearly abundant opportunities for local contractors and organisations to get involved, obviously particularly with the federal government's commitment to making Australia a decommissioning hub of excellence. So we all await the roadmap, which is due to be issued fairly soon, hopefully. But with the aid of organisations such as CODA, who do such a fantastic job, it really is quite an exciting time. So, as Kristian said, a couple of issues to raise. So, as you probably all know, there are a couple of standard, internationally accepted standard form contracts which basically govern decommissioning. So one is the BIMCO DismantleCon, and the other one is the Logic. Now, before these standard contracts were actually introduced, there was really seen to be an unequal bargaining power between, on the one hand, the operators who really had all the control and the contractors who were actually doing the decommissioning work. So what the standard form contracts seem to do or appear to do, is to basically regularise that imbalance. Now, as I said, they're internationally accepted. The two forms are broadly compatible. There are some differences. We'll touch on a couple of the differences, but a lot of the differences are sort of more by way of nuance than anything else. Kristian, can I just... Oh, yeah. So just one of the things that we wanted to talk about is what's common amongst the two forms is both of them rely upon a knock-for-knock liability regime. So all of you in the offshore industry know and are very familiar, no doubt, with the knock-for-knock regime. It's well accepted in the industry. Basically, the loss lies where it falls, irrespective of fault and without any recourse to the other party. So essentially, the operators look after their own and the contractors look after their own. Now, as I said, it's established in the offshore industry, but we need to look out for the carve-outs and the exceptions which invariably sneak into the contracts. So that can be very significant, and it can undermine the balance or the rebalancing that the knock-for-knock actually seeks to do. So we just need to be mindful of that. Now, it's not a perfect regime, the knock-for-knock, but as I said, it's one that's generally accepted and seems to work pretty well, provided that you're alert to the carve-outs and exceptions that invariably creep into the contracts. Okay, just briefly then, both contracts provide for insurance. So the Logic, and this is a bit of a difference, the Logic provides for the decommissioning all risks insurance cover. The DismantleCon provides for insurance, but it basically says you'll take out the appropriate insurance and then lists some of the types of insurance, but it doesn't actually refer specifically to the decommissioning all risks. The other thing that they both commonly do is they specify assumptions. Now, I think the assumptions need to be very, very carefully thought through, which can be difficult at the beginning of a contract because sometimes you don't know what the assumptions are until you actually start the job. But pointing out the key assumptions is really critical. So the assumptions upon which the tender's based, the assumptions upon which the contract is based, for obvious reasons. If there's then divergence from the assumptions, then it can give rise to an actual variation. So there's a cost impost on that as well. Kristian.
Thanks, Pat. So having told you how important it is to get the contract right and to allocate your risks fairly, I'm now going to tell you that your contract may not do what it says on the tin. And that's because of some legislation that we have in Western Australia. It's fairly new development called the Building and Construction Industry Security of Payment Act. Now, you might be thinking, well, we're not part of the building and construction industry here. And this is I think many people in our line of work don't realise in the offshore sector is that this act actually applies broadly. It can apply offshore. If you have a contract governed by WA law for decommissioning work, it likely will apply. What does this mean? This significantly rebalances the commercial and contractual risk allocation between the parties. It means it gives a lot more power to the contractor where it applies. So this is really something that you have to be aware of if you are in the offshore space and you're procuring work. It's not just looking at decommissioning contracts. We're also looking at contracts for materials or services that are used for decommissioning work, and even for services contracts. So you're thinking labour hire contracts, even professional services contracts like engineering and so on. I've got a map here, and it shows, I should say at the outset, this act is not perfectly worded. It's a bit unclear where it applies, but it seems likely that if you're within the yellow line here and your contract is governed by WA law, then the Security of Payment Act will apply, and you need to be aware of it when you're negotiating your contract. Outside the yellow line, out to the end of the extended continental shelf, there's an argument about whether it applies, and because this act is quite new, we'll have to wait and see how that plays out in due course. So what does this act actually do? Well, I've told you that it rebalances things between the contractor and the owner or the operator. Sorry, I've gone too far. There's a few key areas. The first key one is it's about payment terms. The Act has a set process for making payment claims and timelines for payment. And if the Act applies, you really can't wriggle out of it. So it's important to make sure your contract aligns if it applies. Secondly, there's a rapid adjudication process. So if there is a dispute, we all try and avoid them, but if it does happen, then it gives the contractor more power and in getting the disputes resolved rapidly. Thirdly, if there's notice and claim provisions in the contract, it can really modify those by overriding the contractual time bar requirements. And then finally, if you've got performance security in your contract, which is quite common, then it can modify that as well. So things like performance bonds, bank guarantees, and so on. I'm not going to take you through all the detail in the limited time we have, but just to give you an idea of how prescriptive this Act is, I've set out here a bit of a flow chart of how it applies to payment provisions and the rapid adjudication process. There's copies down here if you'd like to take a copy, but I think the take-home message is if you are procuring decommissioning works, or if you're a contractor doing these works offshore in WA, this is really something you need to be aware of and be mindful of it at the front end when you're negotiating your contract. I'll hand over to Pat now, who's going to talk a bit about the decommissioning trailing liability regime.
Thanks, Kristian. So the primary position under the legislation is that the current title holder is responsible for the decommissioning. However, we'll all remember what happened with Northern Endeavour, and as a result of that, trailing liabilities was actually introduced. So essentially, with the trailing liabilities regime, which is now part and parcel of the Commonwealth legislation, former title holders can be brought back to account for decommissioning and to undertake decommissioning, basically. So, for example, if the same scenario happened as occurred with the Northern Endeavour, the government would probably look to the vendor of the asset to actually undertake the decommissioning in circumstances where the then current title holder wasn't able to. So it extends to former title holders, it extends to related body corporates of former title holders, and significantly, although somewhat scarily, it also extends to related persons to former title holders. Now, strictly speaking, that could cover a shareholder. Now, I think it would be a very brave regulator to actually knock on a shareholder's door to actually ask them to meet the decommissioning costs, but just so that we're alive to that. Now, the liability for trailing liabilities is in perpetuity, but it is very much a secondary position. It's a last resort. It's only if the current title holder doesn't or can't undertake the liability, the decommissioning operations, that the government might look to the previous title holders. So it is a matter of last resort. And I must say, I'm personally not aware of any activity or operation that has been stifled by fear of decommissioning liability on the basis that it's a trailing liability. It's been in place, the regime's been in place around the world for a number of years. The UK's had it forever, the US has had it for ages, Norway's had it, and as I said, I'm personally not aware of any impost where a project was actually stopped because of the fear of it. I think that the main thing is knowing about the trailing liabilities and making provision for it at the beginning. So more than anything, it's a question of planning. I'll hand back to Kristian.
Thanks, Pat. And just on that, it's worth noting that when you say that it hasn't resulted in any projects not going forward, that's based on not only our own experience in this jurisdiction, but also working with our colleagues in Houston and London and other jurisdictions. So it's a bit of a worldwide perspective. I just wanted to try and put that into more practical terms about trailing liabilities and see how it would work in practice. So if we take a hypothetical company, Energy Co, they've got a project, we'll call it Quokka, the Quokka field offshore in WA. They've got their parent company, Energy Co Singapore. They've got a bank who's providing working capital, and they've got a minority equity stakeholder, so say a 5% investor. Now, let's say our friends at NOPSEMA issue a prohibition notice and the field has to stop operating. The operator is put in breach of their banking covenants and they go under. It's a situation that might sound familiar to someone in this space. Let's look firstly at the holding company, the parent in Singapore. Now they'll be caught by default as a related body corporate. So NOPSEMA can give them a notice just as anyone else. It gets a bit more interesting when we get to the bank and the position of the minority interest holder. So the bank, if we look at the Act, the test is whether there's someone that's financially interested, and based on that, it seems like they could be brought into the trailing liability regime. But the department has issued some guidelines which suggest that no, banks aren't going to be brought into this because as long as they're providing financing on an arm's length basis on commercial terms. The minority interest holder, though, even though they might only have a 5% stake, they are potentially going to be on the hook for 100% of the decommissioning costs if everyone else falls over. And that might be something that some minority interest holders, or particularly in the in the financial investor space, don't realise. They are someone who has potentially capacity to derive financial benefit, so they are someone with respect to whom the minister could make a declaration giving them liability. So I think what this all demonstrates is it's really important to map out at the start of the project who is potentially on the hook, make sure all parties are aligned and understand their potential obligations before launching into things.
Thanks, Kristian. I just wanted to touch on some of the financial packages that might be available. So, as we all know, decommissioning is a hugely expensive exercise, and throughout the world they're looking at innovative ways of funding and providing securities for it. So instead of actually having cash, for example, you'd have bonds, other forms of security. There are some model or fund models that are actually being developed around the world that can be used to sort of cover this. So one of the measures that's actually adopted in the UK is the decommissioning securities agreement, or a decommissioning security agreement, whereby the vendor actually provides, it's meant to be cash, but obviously that's not always the case, but they actually provide security for the liability for decommissioning. It's a bit of a move away from the clean break that vendors obviously prefer. They prefer to walk away and not worry about it, but the fact of the matter is that's unlikely to happen entirely if there's a risk of trailing liabilities. So in order to cover that, you might enter into a decommissioning security agreement with the purchaser. Now, a couple of things there. It is a move away from a clean break, but also you need to make sure that the funds or the security, whatever security is provided, be it by bond or otherwise, is sufficiently quarantined so that it is available for decommissioning costs if and when it's actually called upon. So just something to be mindful of. Another factor that perhaps arises from time to time is whether in fact there's any tax relief for decommissioning costs. Now, it's particularly complex in the context of trailing liabilities and who gets the tax benefit, who gets the tax deduction, etc. But just something to bear in mind that there might be some taxation relief under the petroleum rent resources tax legislation. So, and it would be also interesting to see, and I'm not aware of any cases yet, how that would impact in circumstances where there's been repurposing of an asset as opposed to total decommissioning. So it remains to be seen. I think that's probably all we were going to say, except for a couple of takeaways. I just wanted to sort of, I think we're all awaiting the government's roadmap with eagerness to see where in fact the government sees the industry going and how it's going to actually promote Australia as being a decommissioning hub of excellence. Kristian, did you have any observations?
Yeah, just on the commercial side, I think for parties that are procuring decommissioning works, or if you're a contractor or a supplier, really important to get the balance of risk right, and you can do that by using one of those standard widely accepted terms. And the other thing I'd say is make sure you understand or get some advice on whether the Security Payment Act will apply to your project. That will depend on where it's located, if it's onshore, offshore, how far offshore, and also what law governs. So it's a fraught area and one that can impact on your project significantly. Thank you.